Hell, ladies and gentlemen, welcome to Coin Matters channel. Our lawyer Jeremy Hogan says to keep an eye out for a certain judgment that's on the horizon. It's significant enough that he told attorney John Deaton, "Thank God, you were in that hearing to force the issue and quote, share with you all the specifics, but because this is about the SEC versus Ripple case and this is the latest development, I'll save you the details." The SEC versus Ripple lawsuit may have far-reaching consequences anyway. If you're an XRP, this might have major implications for you, holder. Attorneys Hogan, John Deaton, and Bill Morgan, all of whom are active participants in the XRP community, have provided me with valuable insight. But before I go any further, I should state that I have no training in law or finance. I am not qualified to give you financial or legal counsel. And remember, you should never use anything I say as a reason to buy or sell something. Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. So, these tweets from the library's official account are what started the whole thing. This is all they had time to write. Our final file to the SEC is due today, and they are likely to be really unhappy. They also include a tiny crossed fingers emoji. The library claims that if John Deaton and Jeremy Hogan read it, they will reveal if it is truly brilliant or incredibly stupid. That's what they've done here, at least in terms of the timing of this is out of the ordinary, and I can't speak to whether or not it's a brilliant legal move or not, since I'm not a lawyer, so I'm going to share with you again with a few of the attorneys within our community, I have to say here. Incredibly, I have access to this legal document, and I am going to share a couple of excerpts with you after giving a brief shout out and credit to attorney James K. File and for sharing it. However, I believe the crypto fundamentals adequately summarized the situation. Pro-XRP attorneys comment on how the recent SEC judgment against the library could impact the ongoing Ripple lawsuit. The library has filed a fresh move in its dispute against the SEC, and lawyers are reacting favorably. Also, from a policy standpoint, we had no idea this was coming. This came totally out of left field. However, it is unquestionably essential. Because, we're in the remedies section here, and you may recall that at the end of January, John Deaton, having jumped in as amicus, he actually was able to get the judge to at least verbally commit to noting that any sort of ruling resulting in library's loss would only apply to those transactions and not to the secondary market, which is crucial, and that's really what's at play here. So, have a look at this. The newest motion submitted by Library in its continuing litigation against the SEC has been met with strong reactions from cryptocurrency lawyers. In its supplemental briefs filed today in support of its motion to limit the Securities and Exchange Commission's remedies in the SEC versus Library case, content sharing and publishing platform Library asserted that it had been focused on getting clarity around using library tokens, which is LBC. That's the SEC's shorthand for a ticker symbol, abbreviated for shares. While seeking a broad injunction that is neither explicit nor clear, the Commission has declined to define the token. In its newest request, the library urges the court to rule that LBC secondary market transactions are not securities, notwithstanding a summary judgment ruling last year in favor of the Securities and Exchange Commission. Because this brief is 7 pages long and I don't have time to go through it all, I'll simply share the section that's highlighted on the screen. This is apparently the library's response to the judge. Okay, then. The Commission recommends a ruling that does not specify who exactly must comply with the injunction. The Commission's proposed judgment lacks the specificity necessary for a final judgment to be enforceable. Whether Library's wholly owned subsidiary Odyssey or any other user of library tokens would be liable to the injunction is left unclear by the Commission's too broad language. First, the language of the final judgment must make clear that only Library violated Section 5 by offering and selling pre-mined LBC at LBC tokens are not in and of themselves a security, and second, nothing in the injunction prohibits Odyssey or other users, from using or purchasing LBC. Doesn't that sound like what I and many others in the community have been saying is of the utmost importance, and doesn't that sound like what I and many because I've known from the start, and I've acknowledged it for some time. We don't care if Ripple loses, especially if they only lose a little bit of money on a technicality related to the amount of the fine they have to pay. Well, the SEC would like for everything to remain hazy, and the outcome can still be beneficial as long as there's a way forward for XRP. As a result, the library is fighting back, pointing out that the SEC is acting in an undemocratic fashion. There must be no confusion. What do you think that will do to XRP markets in the United States, and to whatever degree on a global scale, if XRP holders don't get that level of clarity? The effects, if you will ripple out from the SEC versus Ripple case. However, if there isn't enough clarification, trades won't feel safe bringing it back. This is bad news for any form of XRP owner and stockholder. There will be reduced noise and friction for some types of development while using the XRP ledger. What you do with money determines how crucial liquidity is to you. Therefore, the major fallout will depend on what precisely automobiles are here. But that's why we're having this conversation now. So, have a look at this. In light of this, lawyer Jeremy Hogan has revealed the following excerpt from the relevant library filing. Library argues that the ultimate ruling must specify that 1LBC is not a security in and of itself, and that Odyssey and LBC users are not subject to any permanent injunction the court may order, even while the commission is prepared to create uncertainty. So he's emphasizing the same points repeatedly. Solicitor Hogan commented on that, and his remarks follow. He submitted a brief on behalf of libraries requesting the court to make it clear that the verdict does not apply to the resale of previously owned books. Be wary of this potential ruling. This, sadly, is a real possibility in the ongoing Ripple case, as the SEC has requested a wide and ambiguous injunction while Ripple has asked the judge and the market for clarification. The SEC prefers that these provisions be as wide and ambiguous as possible so that regulated entities are subject to as little certainty and commitment as feasible. Absolutely repulsive. However, that seems to be the local norm. In response to Attorney Hogan, someone going by the name of Hesher Enterprises remarked, "I know commenting on others' legal work is not a great ask. Do you think this motion exceeds the strength or sophistication of their initial defense? I'm curious as to whether the library's defense team picked up any outside insights or strategy for dealing with this move." The big question argument came out of nowhere, no doubt, and it's not customary to be raising it for the first time here, Attorney Hogan responded in a letter. Now consider that. Since the library has never before brought up the topic of currency's usefulness or the worries of its patrons, this is the first time such a specific issue has been raised. They have discussed it at length. This has never happened before with this exact argument and developed in the way that is That's the significant questions doctrine that Hogan, the lawyer, is referring to. And I did a fast search on Google. Over the course of the channel's 2.5 years, I've addressed this topic a few times. From a website I found at random, Open Casebook, comes the following. Regarding problems of great economic or political importance, the big questions doctrine states that courts should not defer to agency statutory interpretations. The non-delegation theory is used by the Supreme Court to justify this restriction. The Supreme Court has made it clear that lower courts, and not government bureaucrats, are responsible for interpreting fundamental legal concerns. Isn't this a really big deal in the law? Do you agree that's how it sounds? This is the central, defining question in the doctrine. Just consider what's at stake here. Consider the longevity and prosperity of a brand new asset class that has just been around for the past 14 years. That's the main thing on the line. This will be delegated to faceless bureaucrats. We're going to let the last bunch of cowards in the SEC handle it. It's good news that the judge in that case has indicated that he intends to make clear that secondary market transactions will not be a part of this once it's all written up, as I mentioned earlier in the video, but I appreciate that the library is pushing back to try to ensure that this actually happens and is being forceful about it. Charlie said that Attorney Hogan, as a lawyer, should know that the court lacks jurisdiction to make such a judgment. Based on the previous judgment, it is exceedingly unlikely that the judge will make any revisions. I must respectfully disagree with it. Again, I'm not trying to pass myself off as some kind of legal expert. I just like to act the part on YouTube. However, whenever any significant concerns concerning doctrine have arisen over the past 2.5 years, I've found myself doing some serious online research. From the outside looking in, it appears like the lawyer, or more accurately the judge, shouldn't be interrupting. A judge can rule on an issue not directly mentioned by the pleadings, Attorney Hogan replied, and he tends to think along similar lines as well. It's common practice to use the appropriate legal term, but care must be taken. Therefore, I value the information provided here, but approach it with caution. Certainly that's acceptable. But I'm simply wondering where the big questions doctrine comes into play if it doesn't apply here. Everything about this asset class hangs in the balance. I have the transcript from the 30th of January, as Attorney Deaton retweeted from Attorney Hogan. To let Naomi Brock know the venue of my appearance. The court did say that secondary market sales would be excluded from his injunction, and he kept his word. I thought the injunction language was too wide. And he vowed that he would never grant such an injunction. Yeah. I pray the court remembers the words of Attorney Hogan, who wrote to Attorney Deaton, "Thank God, you were in that hearing to force the issue, and I hope that the judge keeps his remarks to that effect. Let's pretend you're Attorney Solomon and try to get you into the Ripple hearing with us." Nice. However, this is the case. As we moved into the remedies phases of the case, the judge was informed of the situation as it had been presented before him. All the glory goes to Attorney John Dean for that success. Absolutely. Since that is now available, we may view the transcript. Seeing the details, and we already know like the broad stuff because John was talking about it back then, but he can't make releases just yet, is something I'm looking forward to and will be covering on my channel here. The judge should do what he said he would do and not do what he said he would not do, Attorney Deaton added, adding that he would have to wait a few weeks before publishing the hearing transcript. It seems unlikely, therefore I'm keeping an upbeat outlook. Transcripts. And/or a transcript will be released. Who would be affected if the judge broke his commitment made in court that day? That's not going to turn out well. Let's be honest, that's not a nice look. Here, lawyer Bill Morgan shares his thoughts on the matter. He relayed the following excerpt from the library's official file. It's clear that the Commission does not have the ability to unilaterally apply the 1940 Howey definition of an investment contract to digital assets, even though it does have the authority to regulate and enforce federal securities laws. Congratulations, Ellis Drew, you win. And this is what Morgan, the attorney, had to say. I appreciate it, James. James is in his mind, as evidenced by his retweet of the attorney's brief. I guess that makes it thanks, James. How daring of the library to bring up the big questions doctrine now, after the judge has already ruled on the Howey test's application to LBC, and to argue that the SEC can't apply the Howey test stage to digital assets. A compelling case can be made. Indeed, this is fascinating. And he tells the court that it shouldn't provide relief in effect. Even though it wouldn't be a binding judgment, Ripple and Coinbase stand to lose if the judge rules that the SEC has congressional power to regulate digital assets. That's what I was thinking, too. Chemicals and library books. I mean, how exactly is that going to manifest itself? What we're wondering is how the cost of this record was calculated. Perhaps there are a few leftover morsels? I can't say. There are, however, additional litigation concerning Ripple and Coinbase that you should be aware of. Nothing about this seems positive. This isn't something that could be enforced in court, but it could have a chilling effect on otherwise enjoyable vacations. That doesn't exactly fill me with joy. Do you get what I'm trying to say? It's intriguing to ponder, which is why lawyer Hogan was emphasizing the possibility that we XRP holders may soon be staring directly at this, depending on the course of events. You should get ready for it, though, in case it does occur. The United States is known for its fair and impartial administration of law, but I think it's still very evident that security is never the asset itself. The justice system is not perfect, unfortunately. However, in most cases, the appropriate action is taken. I am, therefore, hopeful. The United States is not a third world nation. This isn't a banana republic or something. Yes, you guessed it, America. Not ideal, once more. There is wrongdoing, but I believe we have reason to be hopeful. You shouldn't use my advice to buy or sell anything because I'm not a financial expert. And please hit the like button and add my channel to your subscription list. So, till the next video, bye.